that is basically the relationship between an employer and an employee. And once they come together and they agree on certain terms, that then forms the employment contract. But we borrow some uh, advice from the law of contract as well to go ahead and say what are the elements of the employment contract. So as you can notice, most of you have contracts or are giving contracts, that there must be a party that is offering something, and there must be a party that is accepting something, and there is always the element of consideration. Now, both the Tanzania and the Zanzibar laws restrict children from being part of the contract, and that's where we also look at the capacity of a person into entering a contract. So if you have somebody who's below the age of 18, you cannot enter into an employment contract with them. And then we look at what are the types of contracts that are available in Tanzania. Now, in Tanzania, we have contracts which are for unspecified period. These are mostly the permanent contracts that many companies like to issue. There is then for a specified period, and normally these are issued to those who are in the professional or managerial positions. And that's where you see where there's a yearly contract, 2 yearly contract, 3 year contract, 5 year contracts. And then we have contracts for specific tasks. So basically, when you have projects, when you have tasks that you need to complete, you may enter into an employer-employee relationship for the period of that project or that specific task. Most of the times, people wonder what is it exactly that goes into an employment contract and what forms, or what is important to note when you're entering into an employment contract with your employee. The most key thing that we have found through experience is looking at vetting your employees. Now, a lot of companies tend to take on employees without doing a vetting. I know of certain companies, and I recently met one, actually even require their employees to come with a police clearance. So you may not want to go to that extent, but when you look at vetting, you're looking at introduction letters from the ward councils, something from the referees, be able to understand their home address. I know of a client who actually has Google Map locations of every employee, um, which could come in handy if your employee disappears and you really need to look for them, or they've walked away with your belongings. So these are a few things that you need to have in place when you're doing the vetting process, you know, and thereafter, it is important to have their relevant documentation, such as their qualifications, their CVs, their certificates, letters of recommendations from their previous employers, if you can get. Often we've noted that uh, companies tend to say, because so and so is working at this organization, they must be really good. So they go and poach that person and bring them into the organization without consulting the other or the current employer. And then they realize that, oh, this is actually a non-performing employee. Now, just because somebody is working for an organization doesn't mean that they're probably the best, or if they're working for a really good organization doesn't mean that they're the best. It's always important to take letters of recommendation or give a call to the previous employer just to find out how well that employee was. The downside to that is if the relationship had broken down between the two, then definitely the employer might not have some really good words to say. So at this point, you may have to use your best judgment. Things that go into a contract should involve the employee's name, if possible, the age, their address, um, their gender, where exactly are they going to be recruited. Job description is very important, and we'll talk about why description is important later. Their salary, whether it's gross or net, it's always easy to circumvent or to deal with the gross salary so that you don't have to do calculations on the net and then start counting, backwards on what the tax would be, what the NHIF, NSSF would be. So gross is always recommended, but some of you may go for net. Having their key performance indicators, again, this is very important so that you can give them their targets and set some goals for them. Again, we'll see why these are important. It's important to share with them the hours of work in the contract. How many hours are they going to work for? Definitely, you need to look at any other issues that you may want to prescribe. I always recommend that the contract should be as detailed as possible, but I understand some of the companies like to keep their contracts very short. And so if you're going to do that, then you need to make sure that you have the employee handbook in place or employment policies in place that the employees could refer to. But mind you, don't keep them in place and not share with them. So again, a challenge comes where sometimes we ask a client, do you have an employment handbook? And they say yes. Do you have policies? And they say yes. Do your employees know about them? And they say no. So don't just leave them on a shelf. Share it with your employees so that they're aware that these are your expectations, these are your policies. But above all, you need to make sure that those policies and those handbooks are in line with the laws of the country. So if you're an international company, then you need to refer to a lawyer to give you an advice on whether or not your policies in Netherlands or in Turkey are applicable in Tanzania. If not, then you may have to amend them and include matters that are concerning towards that jurisdiction. Now, moving forward, once we have our contract in place, that's where the journey begins. And along the journey, we come across many, many issues. Um, and I would start with the probation period. So, as you know, in law, there is a provision for us to have probation. And how does probation work is basically the probation is anywhere between 3 to 6 months to a maximum of 1 year. So if you're going to give somebody or put somebody on probation, then it should not exceed a period of 12 months. However, you are allowed to terminate that person within the first 6 months, um, and you could do it without giving the valid reasons, perhaps. But it's always important to be able to make that decision early. Often, companies feel that they could just have somebody on probation for 6 months and then fire them without any reasons, without giving them their benefits, and so on. Now, there are many cases where this has happened and the courts have decided otherwise. Because one of the things that you need to understand is that no matter what, uh, once they have an employment contract, when you're terminating them, they are equally uh, sort of eligible to receive the employment benefits. So the 1 month notice, the leave, um, which is calculated pro rata, and any other benefits that you might have promised them, those have to be given, even if they're on probation. But the most important thing is that you must conduct an evaluation for them. You must sit down with them and share with them that these were the expectations, but this is the reason why we've not been able to sort of go forward. And there was a case that we came across. I will not name the parties now because I feel like some of the cases are confidential for us. But in that case, there was an issue whether an employee is protected on unfair termination when they're on probation. And it did come across that when when the employee is on probation, on the first 6 months, they're not protected by unfair termination. But then they are protected when it comes to being given their terminal benefits, right? So, and the process of terminating them is the same. When you give your notices and you basically explain to them why you're basically terminating them. Is it because of their performance? Is it because you no longer require an employee? We then go to the contract management itself. So the benefits that come along with the contract is NSSF. We then have the payment of the PAYE. These are the mandatory benefits. Some companies prefer giving health insurance. Some companies prefer giving airtime, sometimes lunch, etc. But those are all optional. But when you're accounting into your cost for an employee, you're looking at basically the NSSF, the PAYE, and you're looking at the SDL, the Service Development Levy, and of course, the leave is something that is mandatory when it comes to the contract itself in terms of the benefits. What then happens when the employee is not performing well or has been incompatible to your institution or is not following your policies? You're then free to give warning letters. And this is something that many companies have issues with because I've always realized that we like to give verbal warning letters and we don't like to put it in writing. Now, the best way to protect yourself as an employer is to put your warning letters in writing and to also back it up with an email or another colleague or a senior manager signing off to that so that you have enough proof that this particular person did receive a warning letter. And just saying that I've been giving verbal warnings on correction is not enough. We then move to what happens on performance. Now, as a matter of practice, when we're looking at performance at a workplace, it is very important for companies, no matter how busy you are, and that is where the human resource manager comes in place, you must conduct performance evaluations because the basis of you raising an issue on poor work performance comes from your performance evaluation, where you will be looking at the job description of the employee, the key performance indicator that you've set for the employee. You'll be looking at whether or not the employee is working as per the employee handbook and policies and the standards of the company. And you will be looking at whether or not that employee is following the orders of their supervisors, their bosses, their directors. So having the work performance evaluation helps you basically put this in place. Now, for those who are in, sorry, I might have, it's probably due to me not having my lunch on time. Let me try and be louder. For those of you,
Please, Shazana, that would be very helpful.
All right, I'll try my level best to increase the volume. For
Thank
those
you.
of you who don't know how to do it, what you need to do is basically you can just develop an evaluation form that goes in line with your company requirements. You need to identify the performance measures that you're looking at. You need to set the guidelines for the feedbacks. You need to create any procedures that go along with that performance evaluation. And you need to have a schedule for the evaluations as well. So if you tackle those things, you can have an evaluation. It is always recommended to do it on a quarterly basis so that in case the employee is not performing, you can put them into a performance improvement program. However, if you feel the need to do it right after a month, you're also free to do so. You don't really need to wait for a whole 3 months to do that. If you feel that an employee is not performing to a certain extent, you can still conduct a quick evaluation and go forward with that. Yeah. We then come to issues of suspension. Now, often we come across situations where there is a misconduct, but it's not to that extent where you need to suspend an employee. But then there are those misconducts that are in between the um, warning letter and termination, where you feel like you need to suspend the employee pending perhaps an investigation that you want to conduct. And so you can do that pending an investigation or pending some. Sorry, I was reading that comment. This is the loudest I can get, to be very honest. Um, so I don't know what to do about it, but I'm going to try and increase my volume more. So when you're looking at suspension, you're also looking at it from a perspective that, let's say you're going to have a disciplinary hearing, you may then want to also suspend the employee to give them time to prepare for it, but also to see that you can carry on with other business while you're preparing for the disciplinary hearing. We're then looking at issues of abscondment. So we do have a recent decision in court now that says that you can only terminate an employee for abscondment if they have been absent for 5 days consecutively, right? Um, but one thing that we need to also note is that in such issues, it's also very important for you to prove that you did try to reach out to that employee. So once an employee is not showing up at work, first day, the second day, you need to try and put in effort to either write to them on email, leave them some messages, call the referees, call their next of kin. If you know their address at home, try and reach out to them. It's always good to show that you made reasonable effort to look for the employee and that you did not just let it go. Often we've seen that clients have gone to court and sometimes have not made it because they simply decided to let it go. And as per our labor laws, this could look like you were actually happy about this person not coming to work. So try your level best to look for that person and put it in writing that you tried to at least get that person to come to work or you made reasonable effort. Now, how do you deal with poor work performance? So I did share with you that you first have to do the usual performance evaluations to be able to determine, but you're also free to put in letters or emails explaining to the employee that you're not performing. Now, for employees that are at a starting level or are not professionals, you may have to go to an extra extent to see if you could coach them, train them, give them some more attention to improve their performance. But employees who are on senior management levels and those who are professionals, where this person is supposed to be knowing what they're supposed to do. For example, if you have a lawyer who is your employee and they're not performing, it is not really your duty to start training them and coaching them because you hired a lawyer to protect you at your workplace. So with such positions and senior management positions who have qualifications to perform certain tasks, you simply can have a consultation meeting with them by writing to them that we want to discuss your performance and give them a warning on their performance. And if that performance is not improving, you may have uh, you may be able to then let them go after that. So it's how you deal with it, it matters, but it's always good to have a strong human resource manager who is keeping track of the poor work performance, the KPIs, the evaluations. Now, for senior managers, you may put them on a performance improvement program if you feel that they're an asset and maybe they can improve. But you then have to make sure that you're following up on that program as well by monitoring their performance. And you just can't go after 3 months or 4 months to say you are on PIP, but you didn't perform, and so we're firing you. So there are certain uh, restrictions to that. We then look at the matter of incapacity, where again, as an employer, you need to make sure that you are investigating what incapacity are you looking at. And if possible, the first thing to do is you need to see whether or not that person can perform any other task and then start making decisions. And it is always prudent for you to make decisions in consultation with that employee because it may not be his or her fault that they're not being able to perform certain tasks or that they're going through a disability due to being ill or having health issues or getting into an accident. So you have to give that opportunity to the employee to share with you what the challenge is. You need to be able to look at alternative jobs, but whenever you're having consultation meetings with employees, it's always recommended to ask them to come with a representative. It's always good to give them that right that they can come with somebody to the meeting so that you're not just recording minutes between you and that person and that person didn't have a chance to perhaps have somebody defend him or her or have a witness in place. So those things will be in your favor if you do them. And so when you are writing those letters, you can do that. Now, sometimes they would like to bring somebody from a trade union. So if that employee is registered with a trade union, then they can come with the representatives from the trade union as well. Um, Whatever outcomes that come up from that meeting, whether it's poor work performance or incapacity, you need to put that in writing and have a brief record of that as well. Now, remember, meetings with employees need to come with minutes so that you can have enough paperwork. As uh, many of you may have seen, if you're lawyers or your companies that have faced cases in court, The onus to prove that the termination was not unfair always falls on the employer. And so you need to show that you made reasonable effort. And how does that happen? It only happens by you having a thick file of paper trail. Wherever you're going to have a paper trail, not just in a labor issue, but in any other issues, even if it's civil cases or other cases, the paper trail will speak for itself. So be mindful of having enough paper trail to back up your decisions. We then go to how do you deal with somebody who's not compatible to you? Now, compatibility can be questionable, but it always goes along with poor work performance as well. But again, it's very important for you to make sure that you lay down your work culture, your ethics, things that you expect the employees to perform or be like into your handbook and your policy. So again, the importance of having a handbook or a policy comes in because if your culture at the office is that every employee must wear a suit, let's say, and then you're finding this person putting on t-shirt and jeans every day, and that means that they're not compatible or their nature or their behavior is not compatible, you need to be able to refer that person to a handbook or a policy document that says this is what we expect of you, right? And again, some of the issues do relate to the work performance. So again, keep a paper trail to make sure that they're also informed of these matters. Now, if there are issues in incompatibility with their fellow employees, perhaps, it's always, again, important to take statements from those employees. I know we had clients where uh, many times there are complaints about, harassment, sexual harassment, abuse, um, the seniors maybe mistreating the juniors not being sort of respectful to the seniors. Now, all these things, if not documented, you will again face problems. So you need to collect statements from those employees who are complaining about their colleagues or those seniors who are complaining about their subordinates or those employees who are complaining about their immediate supervisors. It's very important for you to have, again, paper trail. If there's one thing that I would like you to take back with you today, if not anything, is that for you to be able to have a good relationship and to protect yourself under the current labor law circumstances is a strong paper trail for you to have as record. Lastly, during the journey, if you realize that because of your operational requirements, you can't proceed with this particular employee or employees, whether it's your financial situation, whether it's the company's progress, whether it's that department that needs to go away, what do you do? So again, um, you need to have consultation meetings with your employees. So you need to give a reasonable notice, which is usually more than 48-hour notices to your employees that we would like to have a meeting to discuss the following. You need to put it down on paper that this is the issue we're facing as a company. We're about to uh, discuss your department or we're about to discuss the financial situation. And then you call them for a meeting. You need to minute those meetings. You then also need to sort of have them sign the attendance sheet that they attended those meetings. From there on, You then need to communicate the result of that meeting. After you communicate the result of that meeting, you have to have more consultative meetings with the people you're laying off, on how best can you help them as you're laying them off, because it's not their fault that you're laying them off. Now, again, you need to encourage them to have a representative in that meeting or somebody from the trade union to be there so that all these meetings are minuted, there are witnesses, and there is basically what we call, um, in terms of mediation, we call that a power imbalance, meaning that you as a company are a giant and them as an employee is, just somebody who does not have enough powers to be able to dictate terms. So when you give them support or when you tell them come with a representative, you're giving them the ability to at least have a better say, support system to also back them up in case there is anything. But it also gives you a chance to say, this is, I gave you a chance. You even came with a representative. We discussed this. We have a witness, so we can proceed with ABC. So when you're going through operational requirements, always remember that give the notices, host the meetings, have attendance sheets, minute the meetings, call for another consultative meeting, negotiate their severance packages, negotiate their terminal benefits, give them a chance to have a say in what they may be able to take home. Some employees might even just tell you, we understand the situation, but can I go away with the laptop so that I can do some other work at least, you know, and those are small, small things that you may have to consider. Now, during the journey, many things happen, and some of you may have questions. So I will let you ask me questions at that time. We now move on to what happens at the end. Um, so we have situations where a lot of people ask me, can I just terminate this employee without any reasons? Well, the answer is yes, but the consequences, um, is what you need to consider. So if you don't want to work with somebody because you have a contract with them, if you have a permanent contract with that person, you obviously then have to pay them a compensation of 12 months, their pending leave, and any other benefits that you might have promised them with the severance pay as well. So you can terminate the person without any reasons, but you will then have to pay a compensation. If you are in a contract with them, in a fixed term contract with them, then you may a remainder of the contract. So if it's a year, if it's 2 years, if it's 5 years, then you may be forced to pay that amount. However, the best thing to do is always call them in and say, we are, not having a good relationship with you. We don't want this to continue being the way it is. We would like to lay you off, or we would like to agree to mutually terminate this contract. So how can we do it? And agree on a severance package, try and give them something that they may feel, respected, that may help them for the next 3 months or 4 months where they're looking for another job, and have a mutual termination with them. And so in that, you can sign a mutual termination contract. But again, when you are doing a mutual termination contract, this is like you having a settlement agreement. You must give them the opportunity to seek independent legal advice. You must give them reasonable time to talk and go through that contract. Do not bring them into a room, and just because you know they're going to change their mind tomorrow, force them to sign a contract. Give them enough time whether it's 2 days, 3 days, 4 days, and say, look, go over it, seek independent legal advice, and then come back to us. Now, in many instances, you may also, agree to allow them to draft the mutual termination contract with their lawyer, and then they can bring it to you as well. This will safeguard you more because they drafted it. So always look at it from the perspective that you're giving them a fair chance to mutually terminate the contract. I know there are times where people have gone ahead and complained about constructive termination, that this is because of maybe harassment or it's because of the treatment that they're receiving. This may be because you've put them in a situation where they can no longer tolerate to be there. However, now in constructive termination, uh, it's upon them to prove on how or what happened. So it's not always the easiest um, things to prove, but always be careful on how you handle your discussions with your employees when it comes to termination, so that you're not putting them in a position of constructive termination. And whenever you're treating them, always treat them with humility and empathy so that they feel that you respect them. And although at times you're harsh with them because they're not performing, um, try your level best to put that in writing in the most respectable manner. Now, when you're looking at terminating with reasons, of course, so I have shared with you the other reasons that we can look at in the previous slide, which is during the journey, work performance, incapacity, compatibility, and the operational requirements. But of course, one that is most notorious is when it comes to them conducting a misconduct. And when there is a misconduct, it's always very, very important for you to, of course, make sure that you give a notice to show cause on why they shouldn't be terminated. You need to, if you have to suspend them, you can suspend them for that period of time. But again, you need to get them to attend a disciplinary hearing. Once they have attended a disciplinary hearing meeting, you need to give them a right to representation during the disciplinary hearing as well. You need to give them the usual 48 hours before you call them for a disciplinary hearing. And during the disciplinary hearing, you need to give them a chance to defend themselves. But also, after the disciplinary hearing, you need to give them, in the event that the decision is to let them go, you need to give them around 5 days to see if they want to appeal. Challenges normally come in when people just want to terminate right after that disciplinary hearing. So over there, I will always caution the employers to make sure that they give ample time. The requirement is about 5 days to basically see if they want to appeal that decision. It's always important to see who is the chairperson as well at the disciplinary hearing. So make sure that it's not the top boss or the final decision maker, so that in case there is an appeal, then that appeal can be heard by that particular person. But also, you need to be careful on when terminating, what are the benefits you're giving them. So again, you need to give them the 1 month notice. You need to make sure that you're giving them their severance package. You need to make sure that you're giving them the pending leave. You need to make sure that you're giving them a certificate of service. Now, sometimes employers say, why should I give a certificate of service if there was a misconduct? You can always give them a simple statement that says that Shahzada Wali worked at Stalin Attorneys from this time to this time. That's it. You don't really need to say that he was an amazing employee. Um, so those are the things you need to look into when you are basically terminating them, and the procedures that you need to um, sort of consider. Now, as I said, I didn't want this to look like a lecture. So I know most of you have your own scenarios, you may have your own questions, but I can also see that we have some lawyers who I know are very good at labor laws. So if in case you have anything to chip in case you have any questions you want to ask, please feel free to ask. I know that our colleague Malik has not been able to join today as he was going to discuss issues in Zanzibar. But I will check with Gloria if she can give me maybe another 10 minutes if there are no questions on the Tanzanian part which are burning, then maybe I can address a few issues on Zanzibar, and then maybe we can take on any questions or probably with Gloria. So Gloria, anything on your end?
Thank you, Shazada, for the lovely presentation that you shared with us. Due to the absence of Malik, who was supposed to cover the employment laws in the Zanzibar Island, my first question to you was going to lead you to touch a little bit about the employment laws in Zanzibar. And maybe because of time, and our essence of having this as an engaged webinar so that people could use the platform to ask questions. Maybe if you could identify to us at least two major differences between the employment labor laws practice in Tanzania mainland and the employment labor laws practice in Zanzibar. I mean, just two major differences.
Yeah. So I'll begin with, of course, the types of contracts that we have in Zanzibar. In Zanzibar, because of the nature of the industries available in Zanzibar, basically they have what you call the permanent contract, which we have here as well. But they are very specific when they say permanent contract, and it says that it goes on up to the age of the employee's age of 60 years. So it's specifically saying how many years that contract can go on for. But there could be a voluntary retirement that an employee can have. And then Zanzibar have what you call a temporary contract as well. So because we have a lot of people that go for short-term employment, then you may enter into temporary contracts with the employer, but they're again very specific that it should be between 6 months and 3 years. So they've specified the type of is there. But they also look at within the temporary, there is also a provision that allows you to uh, have part-time contract of service. But now again, they've specified that these are all in consultations with the minister. So in industries that they want part-time employees, they may have to write to the labor commissioner on the type of part-time or temporary contract they're entering into. It's very important to note that in Zanzibar, the involvement of the Commissioner for Labor is quite intense. So even
Yes.
many contracts in Zanzibar need to be vetted and sometimes approved by the Commissioner himself. These are things that you may have to look at when you're having or signing employment contracts in Zanzibar. But then because there are also a lot of casuals in Zanzibar because of the industry, they also allow daily paid contracts. So where you're paying the person on a daily wage, right? And it could again expire at the end of the working day or a month. So again, these are contracts that you can prepare, but the only thing that you need to be aware of is when you're terminating these people, you need to consider the similar termination procedures that go along with similar to the Tanzanian ones. So there's not much of a difference there because we both follow the guidelines of the International Labor Organization, which is, to have a right to be heard, which is also in the constitutions.
Yeah.
So that's slightly one difference I can say in the types of contracts that we have, where we have the permanent, temporary, and the daily contracts that are available. Some instances part-time. The other difference I may say, although I said it along the way, is where that the involvement of the labor commissioner hence in Zanzibar, where it is always advisable that all your contracts go to the labor commissioner, especially when you're dealing with the hospitality industry. So if you're having a hotel, restaurant, you're into the tourism industry. But again, when it comes to termination of employees, I would say, again, Zanzibar, it is somehow mandatory to have that notice of show cause to be in place so that the employee can give it to you in writing as to why they shouldn't be terminated or why a disciplinary hearing should not be taking place for them. So again, whereas in the mainland, in a way, that is not much of a compulsory thing or mandatory thing. The practice in Zanzibar has been that the notice of show cause be quite important. And again, in Zanzibar, they are not very keen with mutual termination. Whereas in the mainland, you're allowed to go for mutual termination. In Zanzibar, mutual termination is looked upon as if you're being unfair on the employee. So there are cases in which employers have suffered because of mutual termination. But again, some of them have abruptly gone and gotten their employees to sign contracts within the space of a month, sorry, not a month, an hour or two, or in a day. So there was a lot of maybe pressure there. Although the employee was okay with it, but then later on they are advised to go. So what in Zanzibar we have the disciplinary handling unit, and in the mainland we have the Commission for Mediation and Arbitration. So that's another difference. But otherwise, the contract management part is usually the same. There's not much of it.
Okay. Thank you so much, Shazada, for clarifying at least the major differences between the employment practice in Tanzania mainland and the employment practice in the Zanzibar island. I would like to thank each of the every attendees who has been patient enough to listening through that session. And we have now approached our Q&A session, and I see questions that are coming in. Once again, I would just like to remind those who have not shared their questions that you could use the chat box to share your question. At the end of your question, please drop your name so that we could address you directly by your name, and would appreciate if your questions are brief. Shazada, we have a couple of questions that are coming in. Would appreciate as well if you could keep your answers, brief as well, so that each question could be addressed as much as possible. Are you ready? Could I start? This is where the webinar gets exciting.
I can see the questions actually.
Okay. So how do you prefer we go about this? Should I read them out?
No, I can just read them out. It may save time. Because I can see
Okay.
Marisha has asked a question here that
Yes,
if an
Shazada. If you
employee
could
was
be more loudly, please. If you could speak more
okay.
louder.
So we have a question from Marisha, which says if an employee was given a
Yes.
short letter and has apologized in his or her response, but you know he's a regular offender, absenteeism, theft, underperformance is terminating him or her fair, then. So again, I'll repeat what I said earlier. Are you documenting the absenteeism? Are you documenting the theft? Have you documented the underperformance by giving them a warning
Yeah.
letter, by pointing it out during the
Mm-hmm.
performance evaluation and minuting it and having them acknowledge what was discussed? If so, yes, you can obviously conduct a disciplinary hearing and proceed with the usual termination procedures. But if you've not been doing that and it's their first instance, and maybe the misconduct is not that big, and maybe you don't have enough proof on that misconduct, then it would be difficult to terminate that person because they may claim for unfair termination for failure of you providing enough evidence that this was something that was continuous, right? Can employer terminate a
Yeah.
contract an employee after expiry of his contract, even if there's a possibility of renewal? For example, if the person was employed as a risk manager and after the expiry of time, the employer doesn't wish to continue with him or her and wants to employ another risk manager. Now, when terminating an employee because their contract is expiring, um, the first thing you need to know is you need to give them a notice of non-renewal. So again, a month before that contract expires, you need to be able to sit down with the employee, have a meeting, share with them that you will not be renewing their contract, give them a non-renewal letter and a notice for a 1 month's notice to terminate that contract. So if you follow that procedure, that's fine. But if you go ahead after the period in the sense that now you've reached to 15th of the month and the contract is expiring on the 30th and you say we're not renewing, that might be a challenge for you because you failed to inform them. But again, it depends what your contract also specifies. Does your contract specify that there is no need for non-renewal? Does your contract specify that at the end of the contract, it will automatically expire and terminate? So again, the choice of words that you use in your contract is very important. Marisha, again, so allow me to come back to the Marisha question after I've answered Dr. Lakshmi. If I have terminated an employee and he or she stated in writing that he or she is not going to appeal, do I
Yes,
have to wait?
Shazada, did you say something?
Yes,
Pardon?
I said I'm going to proceed with Dr.
Yes.
Lakshmi instead of
Okay.
Marisha. I'll come back to Marisha because that's the second question she's asked. So,
Yes.
do I have to wait for 5 days or proceed with termination? Now, in a situation where you have an employee who has put it in writing that they're not going to appeal, um, in my opinion, do not take their word for it because what the law requires you to do is follow the procedure. So even if after the disciplinary hearing, the result is that they should be terminated, you need to give them those 5 days for appeal. Do not leave any stones unturned on your side, because employees sometimes even take their termination and even write that they will not go to court to sue you. But the law
Mm-hmm.
allows them
They
to go
still
to court
do.
to sue. So do
Mm.
not look at that, but instead proceed with waiting for those 5 days. AK, can I insert a specific amount to be paid when one party wants to terminate a contract? And if so, when an employee
Mm.
commits intolerable misconduct, can the contract be terminated without payment? Um, can I insert a specific amount to be paid when one party wants to terminate a contract? So again, it's you can put that, but by law, you may not be able to enforce it. So you need to be careful, because you need to specify what is that amount for. Is it an amount you spent on their training? Did they consent to that amount? What was the situation that that amount was consented on? Because I know a lot of people like to say, if you leave my job, you need to pay me this amount of money. But the law is not has not allowed such things. So by law, that's not something that you can do. But if you're specific about what the amount is for, was it for their training? Was it for their studies? Was it a loan amount? Then you may be able to claim that amount. Marisha, if you're changing the title of an employee while issuing a renewal, can a probation clause be added to this as it's a new designation? Yes. So when you're renewing the contract, you can add a clause that says that since they are starting a different role, or it's a different role issued to them, to me the word would be them now performing a different role, and that role requires you to observe them, then yes, you can add a clause to say that this role is conditional for certain or specific performance by the employee. Um, Dr. Lakshmi again, if an employee has been terminated on the ground of misconduct, is he or she supposed to be paid severance pay? If yes, why? So if it's on the terms of misconduct and it's proven that there was misconduct, then severance pay is not uh, eligible. To add to your response, if it's not their first instance with regards to absenteeism, which has been documented and warning letters have been issued, but the employee asks for forgiveness, but you know he will not change, is it fair to terminate, or would you advise to have termination on mutual agreement? Well, now, if you've met the requirement of issuance of warning letters, which is basically within a specific period of time, not that you've issued a warning letter today and then a year later, it should be within that specific, within 6 to 12 months that you're exercising your right to um, terminate them based on the warning letters. Then, even if they're asking for forgiveness, you may go ahead and terminate them. But if you feel that you were not consistent in the warning letters, or that you issued one today and then you issued another one after 6 months, so they had corrected themselves and then they did well, and then they did it again, then you may have to look at a mutual termination. But um, as I said, sometimes there's no formula to this. So keep as much paper trail as possible. How does suspension affect employee morale in case they return to work? Well, to be very honest, this is probably more of a workplace environment relationship issue. But honestly speaking, suspensions for employees sometimes could lead to them being more difficult to handle, and it may put their morale down. And that's why I say suspension should be some sort of a last resort in case you are either investigating something or you are looking forward to having a disciplinary hearing. So do not just go ahead and suspend employees for small things. Like they didn't show up to work on time, you tell them you're suspended. That may really affect the employees' morale because maybe they have valid reasons or they have certain issues that they may not be able to be honest with you. Nixon, is it true that if the employee terminates a contract, he or she is not entitled with a severance payment? Yes, so upon resignation, you're not entitled to a severance pay. So it's only eligible when it's upon termination by the employer, but upon resignation, you are not entitled to severance pay. I hope I have
Okay,
addressed.
Shazad. As you haven't missed any question, but as we're giving room for others to write down their questions, I have a few questions on the panel as well from my end.
Okay.
Um, in your opinion, how soon can someone be on a performance improvement program?
So performance improvement program, the minimum requirement is at least by practice is about 3 months for you to be able to monitor the employee. But if you feel that they've not improved or they've slightly improved, then you may extend it to another 3 months, but it shouldn't be for more than 6 months. So you need to determine that. And of course, as an employer, you wouldn't really want to keep somebody on performance improvement for 6 months or more than 6 months. So it has to be a
Yeah.
reasonable time, which is at least 3 months for improvement, but another additional 3 months if you feel that they've improved, but they need to still work on a few other areas.
We have a question from Dr. Lakshmi.
Yeah, so there is first from Marisha. Uh, if an employee used to perform a certain task, but due to an incident, he refuses to perform this task, can a show cause be issued on the basis of refusal to perform a task? So if that employee was employed as a cleaner, then yes, you can issue a show cause letter or give them a warning letter to begin with. But if it was due to a fallout with a certain officer, you may want to investigate that matter because um, as human beings, as I said, we although we're looking at it from an employer perspective, but we need to deal with these issues with more empathy and more humility. We need to give benefit of doubt. We need to give a right to be heard. So everyone has a right to be heard, which means that if you give them a show cause, let them give it to you in writing. And then you may sit down with them and discuss this. What was the challenge? Why was there a fallout? And see whether there is counseling required, there is coaching required. What is it that you can do to help that person um, to be able to mend that relationship? As I say, you need to show that you made reasonable efforts prior to just terminating or calling for disciplinary hearings. What is your comment on doing investigation before disciplinary hearing? So now, depends on what kind of investigation this is, right? Um, if it's that is to do with maybe theft or fraud, forgery, any criminal issues, then it is very important for you to suspend the employee and go ahead and do the investigations. The challenge is when you terminate an employee, um, while you've also accused them of, of a criminal offense, and if they do get arrested and they do go to court and their case is in court, then you can't terminate them. That is the biggest challenge you face. So you need to be careful of when are you terminating them? What is the investigation about? If it's a simple investigation, then yes, suspend them, conduct an investigation, give them a chance to come up with their defense, and then conduct a disciplinary hearing so that you can provide your evidence and they can provide their defense. As I said, right to be heard is supposed to be there. Marisha, thank you so much for engaging. But let me start with Kimei. If an employment contract is coming to an end and there is no notification to the employee that there would be a renewal or not, then the coming month, the employer tells the employee that they are no longer employed. Can an employee claim compensation? So as I stated earlier, that the notice for non-renewal must be there. The discussion, the meeting on that employee's termination must be there. You need to be able to give them a notice before you terminate them. And of course, you can claim compensation because it's an unfair termination if it is after the lapse of the period that they were supposed to be informed of. So as an employer, you just need to keep track of the non-renewal or the renewal, and you need to be able to inform the employee or at least have a chat with the employee on what is going to happen, right? As per the labor law, a female staff is entitled to 2 hours for nursing post maternity leave. If the staff is still leaving early and barely doing 6 hours a day work after returning from maternity leave, what would you advise? So again, Marisha, it's very important for you to document these things because the labor law is there as a guideline. If they're not going to follow the law, it is upon you to show that they're not following the law. So if they are still doing less hours and the law is clear, then you need to give them a warning letter and document it. I know sometimes we're emotional about these things, but for you as a company, it's important to have your paper trail in place. But at the same time, you may want to question the employee on what is the reason. And if the reason is medical, or they don't have enough support at home, then you may need a letter from a doctor to say that this person cannot work for more than these hours. So please excuse her for this time because she's feeding or she's having complications, post-pregnancy complications. So again, consultation, putting things in writing, um, making sure that you're keeping a paper trail is important. Gloria, I can see that there are not many questions anymore.
Yeah, maybe if we can keep the chat going, I mean the conversations, and give more room for questions to flow in. Part of your presentation today, you have really touched base on how empathetic, reasonable, and humanity the employers should be. What is your advice on the non-patient employers, non-patient individuals? I think most of the termination mistakes by employers from individuals who are not patients. What is your take-home advice that you could give to such individuals in the workplace?
So again, to such people that are not patient, I would say, look, this is an employer-employee relationship. It is uh, formed with humanity. We're dealing with humans. So being impatient and wanting to terminate somebody, you then need to live with the consequence that, as I said earlier, you can fire whoever you want to. You know, say, I don't want you from tomorrow. But then you should be ready to pay compensation to that person. Or you can be human enough to say, let's have a sit down and discuss. I'm not happy with you, and you're not really performing, or you're creating a toxic environment in my business. How can we agree to end this relationship without me putting warning letters and putting a black spot on your CV, on your career? Because one thing is very clear, that that employee, when that employee goes to another workplace, um, unlike Tanzania, in other countries, people do call the referees and the previous employers. So you don't want me to speak bad about you. So I would rather we sit down and resolve our differences, right? So, but unfortunately, in Tanzania, a lot of employers are just hiring people without getting recommendations and a word from referees. So I would still say that don't do it. Don't just fire people, but follow the procedures. And if you don't want to follow the procedures, have consultations. If you can't be with them in the same room, get a lawyer to do it for you. Get a human resource to do it for you. Get your other directors to do it for you. But don't make impulsive decisions. Um, I can see there's a question from Edina. Is it allowed to
Yes.
deduct the salary of an employee who was absconded from work for 2 days without any permission from his or her employer? Also, is it allowed to deduct his or her NSSF benefits because of his or her absence? I'll start with the NSSF to say no. You cannot deduct NSSF. That is somebody's social security fund. It's a pension fund. You're not allowed to deduct it, take it, use it as a collateral in your loans, etc. Of course, some people do agree on how to best secure a loan through the NSSF, etc. But see if you can involve NSSF in those things. But just deducting, no. Whether you can deduct their pay for abscondment, um, this issue is a bit more sensitive. Does it say in your contract? Does it say in your handbook? Is it in your policy that abscondment will result to deduction of pay? If yes, you may go ahead and deduct because they did not work on that day for you. But again, you must find out what were the reasons. You must give them a show cause as to why you shouldn't deduct those 2 days because of them being absent. So again, follow the procedure. And if you have a human resource in your office, have a lawyer, seek for a legal opinion prior acting in deducting the pay. Do all fixed contracts have a built-in notice? So the the notice period is supposed to be put in by yourself, but in law, we do have what we call the implied contracts. which means that if a fixed contract is expired and you haven't given them a notice, non-renewal, or a notice terminate that contract, uh, then it will automatically renew. So um, always be aware of that. But it all depends on how well you, your lawyer, or your HR has helped you draft that contract. And I always advise clients to, of course, send us the contracts before so that we can review them um, and not just draft them and use Google or templates to just. If an employee has worked 6 days as per labor law, working hours, and had and been paid overtime for Sunday, example, are they entitled to day off on Monday or Tuesday? So the working hours in a week are 45 hours. Um, and depending on your work, basically, in terms of your industry, if your industry requires them to work on Sunday as part of the work week, then you may give them a day off on a Monday or a Tuesday. But it is a bit tricky because the law does require you, if the person works on a Sunday, to give them that overtime as well. But this is more industry based as well. So you may have to consult a lawyer to give you a legal opinion based on the industry you're in. And you may have to have a consultation with the employee on the overtime payment in case the industry you're in requires you to have that person work on Sunday. Overtime, Sunday is designated as a non-working day, as same as a holiday where you're supposed to pay overtime. So you may have to pay that. But again, we need to look at the industry, what consensual decisions you're making with your employee, and try your level best to have consultative meetings. Because if you have a consultation meeting with your employee, which is documented, minuted, you may document this to say that the employee has waived their right to take an overtime because they are going to be getting an off on following day or the day. Yeah.
My next question, Shazada, is on the 28 leave days that every employee is entitled to. We have those people who are aggressive. Let me put it that way in a positive tone, that they're aggressive, and we all know that time can pass by really quickly without identifying that the year is nearly coming to an end, and a specific employee keeps on piling up their leave days but does not want to get paid. So I would say maybe for the year 2022, a certain employee has not gone on leave, maybe has taken 3 or 4 days, but for the next year does not want to get compensated monetary for the the leave days that were unspent, but wants to take them on a bulk, how does the law guide us to such situations?
So usually if you haven't taken your leave day in that particular year, normally you're not allowed to carry forward the leave in terms of now having 28 for 2021, 28 for 2022. It is
Yeah.
upon the employer to basically cut it off and pay them off. They haven't taken it. But again, um, it's the duty of the employer to make sure that the leave is taken as well. So as an employer, you do need to see that you could put mandatory leave days or make sure that you structured your business in such a way that automatically you're giving them leave so that you don't pile up the extra days. But usually the law does cut it off once you finish your first leave cycle within the 12 months.
Okay. Um, Proceeding on the same ground of leave, I understand that during the maternity leave, the law gives room for women employees to go for maternity 3 months leave, and after that get some few hours less from work for the next 6 months to take care of the child. What is your take on the consideration for the men on paternity leave? I understand the law gives very few days for these men to spend time and bond with their new child. How would you advise employers to um, consider leave days for men during paternity?
Well, the question, unfortunately, I'll be biased on this question because man, because of course it is true that it's kind of unfair for men to have only 3 days
Yes.
because men also need time to bond with their children. So, but I have seen companies have internal policies that allow the male employees to have at least 14 days or 30 days as leave. And this is basically paid leave that they get. So I would say that as an employer, this could be an incentive for your employees as well to say that you're allowing your male employees to also enjoy um, time with their newborns. So of course, I do recall also in several conferences that we've recently held,
Mm,
there has been suggestions to the Commissioner for Labor on the change of this, that at least the
yeah.
leave days should increase.
Mm.
So I'm definitely advocating for that. But I know of companies that allow that in terms of giving more time to the father.
Okay. Okay. Jumping to the labor laws practice in Zanzibar, I think we understand that the Zanzibar island is more occupied with the hospitality industry compared to many other areas of practice when it comes to business. And you did mention the involvement of the commissioner when it comes to hiring employees within organizations in the island. Can a commissioner act as a witness when it comes to a labor dispute at DHU or at the High Court?
Sorry, you broke up a little bit for me on this end.
Mm.
Could
Okay.
you repeat that?
Yes, yes, yes. You did mention the involvement of the labor commissioner when it comes to employing of employees in the Zanzibar island. My question was, does the commissioner or can the commissioner be considered as a witness when it comes to a labor dispute that is handled either at DHU or at the High Court?
Definitely, yes. A labor commissioner or a labor officer was involved in either advising or witnessing, approving, can be summoned to court, testify as a witness any issues where they were directly involved. But otherwise, you cannot just summon them for interpretation of the law. They have to have played a certain role in witnessing or advising or responding to your letter or responding to your seeking for opinion. Yes.
Oh, okay. All right. We have a question coming in from Dr. Lashmi. We appreciate everybody's involvement. Please do keep the questions coming. We have about 17 more minutes to still keep on engaging. We highly recommend the questions to keep coming. Shazada, please, you can proceed.
If an employee has finished his or her ED and she or he is able to resume his or her duty, what's your comment? Correction. If an employee has finished his or her ED and she or he is able to resume her or his duty, what's your comment? Oh, not able to resume. Well, that would lead us to looking at the reasons for incapacity, right? So this would mean that they have a health condition that they cannot continue working for you. In that situation, you do need to have a consultation meeting with them, get a doctor's note. If you have your own doctor or hospital you trust, you can get that verified as well, that they are no longer in the position to work. And so what that would do is you would then be able to sort of uh, terminate that employee, but you may have to do that in consultation with the employee as to how that termination takes place. So it's a sensitive issue. You need to understand that is the employee telling you they'll be able to join or resume work after 1 month, months, 3 months? So again, the labor law here under Regulation 21 or Code of Good Practice does lay down the procedure on what to do, but sensitive issue, it's a tricky one. So on a case-to-case scenario, you may have to seek for a legal opinion from your lawyer, but always good for you to do your own investigation as to what are the reasons and how best can this person be laid off without it having an impact on their life uh, and making them feel that you're letting them go just because now they're sick or they have health reasons.
I feel that was a very critical and important question that is very applicable. We have another one from Edina.
Yeah, so I think Edina's question, I think her question is very similar to yours,
Yes, I agree.
right? Which I had addressed that if an employee has not taken his or her annual leave, what does the law say about it? What are the employer responsibility about it? So yes, if they haven't taken their leave, then you would be obligated to basically pay them in lieu of that leave. Um, it is not encouraged to carry forward the leave. Um, but as I say, some employers do end up carrying it forward, and but they would not allow that employee to take now maybe 2.5 months of holiday. So again, you know, um, having consultation meetings with the employee, agreeing on the best way forward is what every employer should do. And this is where the importance of a human resource manager comes in place, where you have the HR or a lawyer that can help you um, work through that scenario, because it's a tricky one where you need to handle it with care without making it feel like you are not giving them a right to their leaves. For employees who are taking their little ones for vaccine or clinical issues, what type of leave will an employee take? So usually, um, when you're taking off for these minor things, uh, it's usually there's no particular leave for that. I honestly haven't come across uh, something that says that this is a particular type of leave. I don't know if there is another lawyer on the in the call who has a name for it, but basically um, we it could be put under some level of compassionate leave, but I've never seen employers actually be sort of harsh on their employees who want to attend an hour of their children's school parent-teacher meeting, or medical issues for their children. Because again, as I said, we're dealing with empathy and humility here. So I'll be very honest. There is no particular name to that leave that I know of.
Okay, thank you so much, Shazada. Maybe I would just like to kindly advise the attendees once again that our session has been recorded, and it will be posted to our YouTube channel, where you could subscribe under the name of Stallion Attorneys. Please, again, feel free to follow us, like, and comment on our social media pages, in Instagram, Facebook, and Twitter. And all of them go by the name of Stallion Attorneys, to be able to get notifications of all our next webinar sessions. What will they be about, and under what platform will they be on, so that you could be involved and notified earlier. Once again, I appreciate for the presenters, definitely, for engaging with us today. It has been a remarkable session, and all the questions, please again feel free to visit our website, stallionattorneys.co.tz, to get acquainted to the areas of practice that we practice at the firm. And you could reach us through our email, our center email, which goes by ask@stallionattorneys.co.tz. Our email is also found through our website, but also found through all our social media pages. So you could get a link to our email, you could get a link to our website through our social media pages. We really do, again, appreciate the involvement throughout. Shazada, through the last minute, what is your final take um, to the attendees who were able to join today, keeping in mind that our attendees is a diverse group, whereby we have business people here, we have uh, law students here, we have other general entrepreneurs who have joined, and we also have employees. what advice would you give as a take home for each individual?
Thank you, Gloria. I think my parting words would be, number one, if you're an organization that can hire a human resource manager, please do. If you're an organization that can have a lawyer on retainer, please do. But if you're an organization that's a startup and you feel like you're not able to incur such expenses, then it is always prudent to, again, I'll use the words, deal with your employees with empathy, with humility, with respect and dignity. Follow the rules when it comes to rights to be heard. Don't be impulsive. Don't make decisions rationally. Try your best to make sure that you're documenting everything that is going on between yours and your employees' relationship, whether it's failing to provide to your customers, whether it's coming late to work, whether it's being unsupportive, abusive, not cooperative at work, whether there's a complaint filed. So try your level best to document everything. Make sure you do your performance evaluations and have your contracts right. You know, the foundation, if the foundation is strong, you will be able to have a cordial relationship and management of the employer-employee relationship. So I would obviously advise that, make sure that at least when you're drafting your contracts, your job descriptions and your KPIs, and so involve a lawyer, involve a human resource manager for that. Yeah. Thank you.
Thank you so much, Shazada. I can see on the chat box people are asking on if and how they could get the presentation. I mentioned before that the recording will be posted to our YouTube channel, but we will also drop an email, a broadcast email with the link and the brief presentation that Shazada has shared. We once again appreciate everyone. Through our email address that we have just shared, you could also share your areas that you wish we could cover next. We would really, it will be very precious for us to make sure that whatever topic that we are discussing makes a change to the society, and we would not want to be able to discuss on topics that are really not relevant to our day-to-day operations. So please feel free to write to us on what areas you would like to hear from us, and we'll definitely put it on schedule. Once again, thank you all. I really do appreciate it. Please forgive us if there was any setback when it comes to the internet connection, when it comes to the audio of the speakers. We'll really do better next time. In the meantime, I would like to introduce myself. I'm Gloria Mokasole, practice manager at Stallion Attorneys, and I was the moderator for today's session. Thank you all and have a lovely weekend ahead.